Welcome, everyone. Welcome to Patent Law Textbooks, a micro symposium. I'm Jason Rantanen, the David L. Hammer and Willard L. Sandy Boyd Professor and Director of the Iowa Innovation Business and Law Center at the University of Iowa College of Law. Today, it's my great pleasure to welcome all of you to this panel discussion on patent law textbooks. I'm thrilled to have this spectacular group of author panelists with us today. So welcome, everyone. Just as a reminder, this program is being recorded and will be made publicly available at the conclusion of our program. So let's start by briefly meeting each of our author panelists. So our first panelist is Craig Nard of Case Western School of Law in Cleveland, Ohio. Next, we have John Duffy of the University of Virginia School of Law. Our next panelist is Daniel Breen, IP Counsel at Phillips. And next, we have Sarah Burstein of the University of Oklahoma College of Law. Our next panelist, I'm not sure he's with us, is the Honorable Randall Rader, retired, former circuit judge and chief judge of the Federal Circuit. And then we have Mark Janis of the University of Indiana, Bloomington. After Mark Janis, we have Scott Keefe of GW Law in Washington, D.C., and finally, Lisa Larimore-Willett from Stanford in Palo Alto, California, who's joined by Jonathan Mazer of the University of Chicago Law School. You could join us. I'm so glad to see all of you with us today. All right, so I'm going to give each of our authors the opportunity to say a few words about their patent law textbook. We're going to start with Craig Nard, who is the Galen J. Rusch Professor of Law and Director of the Spangenberg Center for Law, Technology, and the Arts at Case Western Reserve University School of Law, and the author of Craig A. Nard, The Law of Patents, Walters Kluwer 2019, the first textbook that I actually used to teach patent law. So welcome, Craig.
Thank you, Jason. It's a pleasure to be here. Thank you for putting this together. I think it's a terrific idea, and it's also a pleasure to see some old friends. So let me start in sort of the 3 or 4 minutes that we have to chat a bit about the book, the sort of philosophy of the book, some of the things I thought about. There are really 2 different lenses that I looked through when putting the book together. One was pedagogical, of course. The other one was sort of from a durable relevance lens. You know, how do you make this book stick and have relevance after the semester ends, something that students would want to have on their desk or their bookshelf, for instance. So through those 2 lenses, you know, on the pedagogical front, you know, you want to introduce, I wanted to introduce sort of the foundational doctrinal and policy, but also make it accessible. So in chapter 1, you start with some basic concepts. The patent gives you the right to exclude, and sort of unpack that, give some examples. It seems to me that that's one of the things you really have to introduce early to just get a vocabulary for the students. And then sort of get into some of the history and the economics of patent law, to talk about the justifications for the system, some of the incentives for the system. Why do we have it? How do we sort of answer this question? Why do we have a patent system? In class, I frequently begin with a slide from Fritz Mackliff's famous study, where he ends, you know, if we didn't have a patent system, it would be irresponsible to create one, but since we do have one, it would be equally irresponsible to dismantle it. And so what does he mean by that? And so we talk about that a patent system arguably has more benefits than cost. And what are those benefits? What industries rely on it? What are the costs associated with it? And so you sort of frame it that way in chapter 1. And then the question was, okay, what do you do? What are the sort of the big picture concepts? I thought it was important to start with the big picture stuff, something that's accessible. And so chapter 2, with this, the first substantive chapter, or the chapter that first introduces the doctrine of patent law. It's the disclosure requirements. I thought that was a good place to begin, section 112. And the claim is introduced very early on. With the Phillips case, the power of the claim, the dominance of the claim, this person of having ordinary skill in the art is introduced. What is this person about? Because we know that this hypothetical person is a very prominent force in patent law. And what is a claim, and why is it so important? So that claim is sort of a nice foundational piece. And then I thought, well, let's move into enablement. And so you start with the claim. what does the claim look like? How do you interpret them? What are these interpretive tools? What is its importance? And then let's step back and look at the bargain that the inventor makes with society, and that's really enablement, that's the disclosure. And that feeds in nicely to the incentive to disclose, the sort of disclosure justification that's so important. And so we begin with enablement. O'Reilly v. Morse is the first case after Phillips. And there I always thought O'Reilly v. Morse, right, it's a 101 case, but also 112. You could look at Tawney and Greer's opinions, and they really sort of position themselves in a way that gives the instructor the opportunity to talk about so many important things in patent law. The relationship between the spec and the claim, how the spec keeps claim scope on a leash, this notion of commensurability, what does the inventor have to do? What does that bargain look like? Tawney very much focuses on improvement activity, the ex post side of our continuum, ex ante, ex post continuum, where Greer makes some very good points and focuses more on the ex ante side of that continuum. And so that's a nice case, I think, to talk about the bargain that the inventor has with society, but also bring up some of these very important concepts that both Tawney and Greer raise. And then you sort of start drilling down into the weeds a little bit. Then you say, okay, here's enablement, here's what it seeks to do, here's this relationship with claim scope. And then you start talking about undue experimentation, move on to the written description requirement and definiteness. And I found that that really gives students, it's accessible, it's stuff that they get, except Ariad, I think, is always, for me, is always difficult to teach. But that bargain, they really understand. And then it goes from there into eligible subject matter and utility and novelty, et cetera. The final thing I would say is with respect to the lens of durable relevance, like how do you make a book relevant long after the semester ends? And so I think I try to make the book more treatise-like as well as a case book. You did that, but in chapter 1 have very extensive footnotes, particularly on the history and the economic side. But also with respect to the comments that follow, I try to answer more questions than I ask, and to give students several articles, references, cases in an extensive way that they could go back to once they're in practice and say, oh, I remember this, I remember that. And I've actually had some decent feedback along those lines from former students. So that's it. So I have those two lenses, pedagogical, durable relevance, starting with the big picture and sort of drilling down from there. So why don't I end it there and turn it over to you and John.
Terrific. Well, thanks, Professor Nard. And I've got an image of Professor Nard's book right here as well. We're next going to turn it over to John F. Duffy, who's the Samuel H. McCoy Professor of Law and Paul G. Mahoney Research Professor of Law at the University of Virginia School of Law. He's also the co-author of John F. Duffy and Robert P. Merge's Patent Law and Policy, Cases and Materials, Carolina Academic Press, 2021. And this is actually the book that I used when I was in law school, the very first edition in binders many years ago. So it is terrific to have you with us, Professor Duffy.
Well, thanks very much for inviting me. I hope you can hear me just fine. I actually agree a lot with what Craig said, which is not surprising because he and I have co-authored before, and we have probably very similar views about the academic project in general. When I was asked to join what was then just the Merge's casebook, and Rob asked me to join up and co-author the third edition, the first two editions he did alone, I thought about what was the model, what was the best casebook I had in law school, and which ones did I not like? And the one that I really liked head and shoulders over all others was the Hart and Weschler casebook on federal courts, which was then, I think, only in its second edition. And what I loved about it was dense. Now, that may not sound like a great goal if you're saying, what do you want your book to be? I want it to be dense. No, but it was just the amount of detail in the book, especially in the notes. The cases were there, the main cases were there, but the case books I didn't like the notes afterward would be very short, and they'd be sort of along the lines of, what do you think about that argument? And I quickly began to realize those are kind of easy to write. Well, what do you think? But I think the hard notes to write are the ones that say, here are things that are going on in the case, in the history. Here's why this case is viewed as a watershed case, and here are some of the interesting points that you might want to pay attention to if you're a student. I love those notes. I love the details, and so I think Rob's book was already like that, and I made it more so. I tried to make it more so and add to it. The other thing I added, which was new to the casebook, and I see a lot of casebooks now have things like this. I have I added a chapter, and this was new when I joined the casebook, on the legal process of the patent system. And I'm pretty proud of that, because I think that at the time, this idea that there was that the process could change and change quite radically, and was in the process of being changed, I think was a new idea, and we put in there a lot of administrative law as well as patent litigation materials, and so I'm really proud of that. I think obviously that chapter has been a source of growth in the last 20 years because things have changed a little bit. Then I guess in terms of the things that I care about are obviously teaching. We just reorganized the casebook, and that was, I think, I had a big hand in prodding Rob to do that, but Rob and I both agreed on certain features, and we can talk about that later in the discussion. But we did reorganize it. I actually looked through all the organization of all the books that we have here represented today, and I think we're actually quite similar in many ways. We all have sort of an introductory section. We then have patent validity, and then we have infringement and remedies. So there's some general agreement. I think how to introduce those validity chapters. I think there's a great deal of diversity, and I'd love to break out and talk about that more. And the final thing, and this is again consistent with something Craig Nard did, was we wanted to try to be influential. And I think sometimes we are. So one thing that I remember distinctly is about the 4th or 5th edition. We were getting pushback from our publisher to cut things, and I was looking at various things to cut. And I felt like, well, we have this introductory case in infringement called Merle versus Yeomans, which was, again, an addition that I made to the casebook, that I added to the casebook. And it was kind of this old Supreme Court case that hadn't been really cited a lot. And I thought, like, maybe, we should just make that a no case. And then I checked the citation pattern. And in the 20 years before our edition came out, it had been cited 13 times in all courts. Now 20 years afterwards, it's been cited 119 times. And I get the feeling that that's because we put it up there and said, this is a watershed case. It was not so much a standard citation. And in fact, it's also influenced the law reviews. TJ Chang and my colleague Larry Solom have a whole article in Yale Law Journal about Merle versus Yeomans. I now have a symposium piece on Merle versus Yeomans. I think that, that trying to actually influence scholarly debate, I think, is part of what of what we'd like to do. Thanks a lot.
Well, thanks, John. Again, I've got an image of our patent law and policy book here as well, so you can fix it in your mind and you can think about what it looks like. So our next speaker is Dan Breen, Intellectual Property Counsel, Sleep and Respiratory Care at Philips, and co-author of Daniel H. Breen and Ned Snow, Patent Law Fundamentals of Doctrine and Policy, Carolina Academic Press, 2020. So welcome, Dan.
Thank you. Thanks so much for the invitation. I hate to join the chorus, but I do think that John and Craig both made some really important points about, I think, any good casebook, including patent casebooks. I definitely wanted, Ned and I wanted to create something that was something of a hybrid treatise and casebook model, because we think there's definitely space for some in-depth explanatory portions for students to sort of set the scene, but cases, of course, are tremendous teaching tools. Durability and relevance was important to us as well. I think what drove us perhaps more than that even was we've really embraced the idea of creating an introductory text. We resisted the sort of pull toward comprehensiveness and what if we don't say this, or what if we don't say this, what are the students missing? And ultimately we sort of focused on depth over breadth of the fundamentals. And what we considered fundamental were the issues that arise often in practice, the issues that are going to be litigated, the issues that are going to be argued to the patent office. And we just limited the discussion of things that don't come up all that often or that are academic. And I don't mean that in a pejorative way, but that they're just not arising all that frequently in some cases. So for example, I don't think we mentioned the reverse doctrine of equivalence. I think there's a footnote in there about plant patents. We wanted to be introductory. And so some of these topics would just muddy the waters and confuse things for students. And that's in the spirit of making it approachable. We really wanted patent law to be something that students of all different skill levels, different technical backgrounds, different degrees of interest in even becoming patent professionals, that they all could find something that they like and enjoy about patent law. So in terms of implementing and trying to accomplish all these goals, one of the things that we really focused on was having a sort of mini treatise to introduce each concept. So there's several pages usually of explanatory text up front with diagrams, summaries of the history, key doctrinal turning points, key cases. And we use the cases as ways to supplement that learning, not to drive the discussion, but more to reinforce the learning that came from the upfront reading. So we'd select cases, a mixture of the old favorite classics and some of the newer cases. Simple technologies were our preference. Again, we wanted a student who, let's say, had interest generally in business law or or marketing law, something of that nature, where having the ability to speak from some educated perspective about what the patent system is for, what happens if a patent issue comes across your desk. We wanted those students to not be turned off by the idea of patent law, either because the cases that were selected were too technical, or because we would send a message somehow in our text that the patent law was really only for those people who want to be patent lawyers. Another thing that we did that I think was pretty successful is, of course, we have the traditional case notes. We use those as opportunities to show sort of branches or forks in the road beyond what the case taught. We also have, I think, a pretty pithy section of case comprehension questions where, once the student has read the case, we can kind of tee up the key issues, go through each one, make sure that they didn't miss anything that we think is important. As far as the organization, I agree, with John's point, a lot of similarity. Patentability makes a lot of sense in my mind to do first, infringement and remedies later. So our introductory chapters were, similar to what was described earlier. We focused a lot on what patents are used for in the very beginning. Why would you want a patent as an asset? We talk about justifications. We have a pretty in-depth overview of patent prosecution, with examples to just show students the process of getting a patent. And we started with disclosure requirements up front as a sort of jumping off point from the patent prosecution discussion. One of the things that I think we were pretty happy with was, we had a challenge in covering pre-AIA versus AIA law. And one thing I was really pleased with is we've gotten good feedback in breaking up the idea of prior art and novelty into two distinct chapters, 5A and 5B, just to signal and reinforce to students that there are commonalities, but there are differences. And only then do we go on to things like anticipation, non-obviousness, and we reserved utility and statutory subject matter until after all of that, because frankly, a lot of times it doesn't come up, and when it does, it's very confusing for students who don't have, I think, some prior understanding of at least the novelty and non-obviousness issues. And the last thing I'll say is, we have lots of examples and explanations throughout. We wanted those to jump out of the page so students can know that they're going to get some clarification coming up soon. Every chapter has practice problems and essays with answers and sample essay responses that the students can find. So professors can use those as teaching opportunities, or students can do them on their own. And we also have a teacher's manual that has a lot of additional suggestions for discussion topics and extra problems, and even additional cases that the professor might want to use to assign as a supplemental reading.
Thanks, Dan. Our next panelist is Sarah Burstein of the University of Oklahoma College of Law and co-author of Sarah Burstein, Sarah Wasserman-Rajek, and Andres Sawicki on Patent Law and Open Source Casebook. So welcome, Sarah.
Thank you. So our book, we're super excited about it. We just introduced it this summer. We think patent law is cool and fun, and we really wanted to share that with our students. And I think that's sort of reflected in our book. Thematically, we really put a lot of thought into focusing on patent law as law, right? Not just as tech policy or science law, but we talked about canons of construction, history, and really just put the law at the forefront. There's a lot of common law development, and we hope that this book will be helpful for students who, like Dan was mentioning, maybe they're not necessarily going to be patent lawyers, but they can still learn a lot from this chapter or from the book. As far as the design of the book, we focused a lot on making our book accessible and inclusive. It looks pretty traditional, right? Even though it's a born online book. And that's because there's this principle in design, sometimes called the Maya principle, right? The most advanced yet acceptable. And the idea is that consumers don't always want the most avant-garde thing possible. They want to go like just far enough that it's still within the realm of acceptability, right? We didn't want to go with something that was so different that it was going to make students uncomfortable or frankly undermine the credibility of professors, especially younger professors and professors that are not all white men, right? This is a real issue, sort of having a book that brings credibility with it and shows it, right? When I walked into my first patent class, my students didn't necessarily assume that I knew what I was talking about. And so the book, having a traditional looking book, we think helps that and makes it more accessible both to junior professors and to students. We also, in the spirit of inclusivity, we love that our field is growing and has so many voices, and we really wanted to reflect that in the book, to cite a wide variety of authors and reflect that welcome and inclusive community that we see in patent scholarship more broadly, right? Patent scholarship and the patent scholarly community. So we tried really hard to focus on that because we know students do use their books to start their research, right? And this idea of who is a credible authority is really going to be an important thing. And so we wanted the book to be accessible, again, for both students and early professors and first-time professors. So one part of that too is we didn't bake into the book any assumption that you were going to teach the book in the same order we did, right? We had to pick an order of chapters because we had a print copy, but we didn't say things like, oh, like you already read, you know, and then reference a prior chapter, because we know that sometimes people jump around. And again, with this, we wanted to reinforce the authority and the credibility of our professors who might want to adopt the book. Some other things we did, there were a couple cases that I thought it was kind of, I always struggle to teach like John Deere, right? Because there's a whole bunch of law you have to put out, and then there's the facts of all the cases. So we did a couple of cases where we flipped them, right? We put all of the law in the case excerpt and the facts in the notes. So you could kind of separate that out. And at least so far, that seems to be teaching well. So that's kind of one change we did. And then, of course, no one who knows me is going to be surprised at the fact that I really, when I started this project, me personally, was interested in making a really great designs chapter, right? And including and making a book that took all types of patents seriously. Now, that's a different approach, certainly from the frequency approach that we've heard about before, right? But it was an area where we thought we could add a lot of value for both students and for the practicing bar. If you go to a firm, you're going to have partners who are going to know the details of utility patent law. They might not know about plants, right? And that's an area where there's a lot of increasing interest. And that chapter also, to go back to the original point, is really kind of a statutory interpretation chapter dressed up with a lot of plant trivia. So we hope that even for people who aren't going to do plants, it would still be a really valuable chapter. So that's the overview of our book.
Thanks, Sarah. And if you haven't seen the book, this is what their book looks like. It's that nice purple cover with the pretty hidden design underneath it as well. So our next book is, an author is Judge Randall Rader, retired, former circuit judge and chief judge of the United States Court of Appeals for the Federal Circuit and current principal of the Rader Group. He's co-author of Martin J. Edelman, Randall R. Rader, and John R. Thomas, Cases and Materials on Patent Law, West Academic 2019. So welcome, Judge Rader.
Thank you very much. And, I taught my first 2 years at the University of Virginia out of the Merges casebook and still have a lot of affection for that and for the marvelous contributions that Professor Duffy has made to that. And using that kind of as a starting point as we went into our project, which is now in its 5th edition, and we're looking to a 6th very soon. The one thing that we particularly wanted to focus on was the international aspect of intellectual property. Technology knows no boundaries, and the law, of course, does. And so we need to accommodate an international technology in a series of sovereign jurisdictions. We find ourselves doing a lot of commenting in each section about the law in China or Japan or Europe, primarily England and Germany. That took on a particularly unique aspect in our last edition, where we added a rather substantial chapter on comparative law using standard essential patents as the model. Now, by the way, just try to digest Unwired Planet and Huawei versus ZTE. You'll find there's a real challenge in making those accessible to students, but we picked a few principles from each of those and tried to capture the diversity of the enforcement systems around the world and how those influence the law. And that's become kind of an important part of our teaching process, as well as our casebook presentation. As I say, we'll be doing a 6th version probably next year, 6th edition. I do have one question for this group, which is probably a major point I'd like to get insight on, and that is how are we all dealing with the prior art changes of the AIA? For some period of time, we need to still deal with the priority rules of the old regime, and yet we're probably reaching a point where, at least we think we're reaching a point in our last edition, primarily focused on AIA prior art. And I think we'll move almost exclusively in that direction with maybe one case. I like to throw the Gould case in. It's an old case, but it really captures the diligence, which seems to be the linchpin of the old priority contests and interferences. But I think the one aspect that we kind of emphasize is this international impact of technology of course, this is a U.S. case book, and we start every chapter dealing with the U.S. law, but we try and find some way to work in the implications around the world. Once again, I've been inspired by the writings of almost everybody on this this call, so it's a joy to be with all of you, and I look forward to hearing more. Thank you very much.
Well, thank you, Judge Rader. And if you haven't seen the book, this is one of the earlier editions of Edelman, Rader, and Thomas. So our next speaker is actually my predecessor at the University of Iowa, Mark Janis, the Robert A. Lucas Chair and Professor of Law and Director of the Center for Intellectual Property Research, Indiana University Bloomington Maurer School of Law, and co-author and executive editor of Mark D. Janis, Ted M. Sickelman et al. Patent Law and Open Source Casebook, Law Carta 2021. Welcome, Mark.
Thank you, Jason. I wish I could be there in Iowa City, I got to tell you. But it's great to be here with the group. So let me say a few things about the basics of the book and a little bit about how we put it together. So Ted and I are the primary editors, as Jason mentioned. We've got a large group of chapter contributors. The book is strictly devoted to utility patent law. It's suitable for 3-4 credit hour patent law classes. I've used pieces of it for an advanced patent law class as well. It's got 9 chapters in it currently. We've got other materials to add to it, IPR, PGR practice, some other things, and some teaching support materials that are in process that will add to it. This is a book. It's a new book, but with a longer history than you might expect. Ted launched the project. He can speak more to it, of course. He originally gathered the author group in somewhere around 2014 or so, 2014, 2015, asking each to contribute a chapter. And at that time, of course, there was no open source patent law casebook, at least as far as I'm aware. Separately, I had been developing supplemental materials going all the way back into the 90s. And I just happened, before we got on, I had one on my shelf behind me. So, well, yeah, you can't see that it says University of Iowa on it. But this was when it really was a cut and paste job, literally. And I noticed when I opened it up, one of the first cases was this really new case just decided by the Federal Circuit called Markman. So it seemed like it might be kind of an interesting case. What happened was, as my supplements grew larger and larger, they finally reached a point where it seemed like it made sense to create an entire book. And that was about the same time that Ted had gathered all the co-authors' chapter contributions. So we talked and decided that it would make sense to blend these two projects into one book. So we did that, and I taught from it starting probably around 2017 or so. Had a chance to do that several times before we released it on SSRN and through Law Carta just earlier this year. So wanted to just say 3 or 4 things about what we hope to accomplish with this book. I'm sort of saying what I hope to accomplish. Maybe Ted will contradict me. We have such a big group that there may have been lots of objectives there, but first, it's exciting to be part of the wave of open source books for lots of different reasons. I thought I ought to take the point to mention, though, that I'm very conscious of the vast amounts that I learned from the predecessor books that, Merges before it was Merges and Duffy, Marty's book with Judge Rader. Those sorts of books always influence what comes afterwards. I think it's important to acknowledge that. So that's thing number one. Secondly, we really sought to apply lessons that we had learned through sort of a long stretch of teaching and publishing other case books. So things like interspersing problems, paying a lot of attention to interstitial narrative between the cases, cross-referencing, being thoughtful about trying to think about the best uses for notes and questions, and so forth. Third, we wanted a book that would reflect the accumulated practice experience of our group, which is really extensive. And one challenge that we had there that I think we continue to grapple with is how to create a book that is really useful for students who are going to go into primarily a patent prosecution practice. How do you create a book that does that doesn't turn into teaching of the patent bar, but really reflects how these doctrines, though developed in litigation, might play out in ex parte context. So that's an interesting challenge. And lastly, we wanted to allow for some amount of modularity and flexibility with this book. It's open source after all. And one good example of that, Tom Cotter has a very rich chapter in this book on remedies. And he breaks that off and uses that as foundational materials for a standalone seminar or course that he occasionally does on patent remedies. So we thought that's a good thing, nice thing to be able to accomplish with the book. So those are a few things about what this book is like and how we put it together. And I'm glad to be part of the panel and look forward to the discussion of all these issues as we go forward. Thanks a lot.
Thanks, Mark. Our second to last panelist is F. Scott Keefe, the Fred L. Stevenson Research Professor of Law and former Commissioner of the U.S. International Trade Commission, and co-author of John M. Golden, F. Scott Keefe, Pauline Newman, and Henry E. Smith, Principles of Patent Law, Cases and Materials, West Academic 2018. Welcome, Scott.
Thank you so much for bringing us all together and bringing us all together around such a fun topic. So many of the folks in this community have really enjoyed helping and sharing ideas with each other so much. And I think that for our book, that sharing of ideas and that standing on the shoulders of giants and standing next to the shoulders of giants way of thinking was a big part of the project. So we've got what we think is a plurality of viewpoints that brings an approach to patent law that is, we hope, especially well anchored in the way practitioners use patent law, the way academics think about patent law. And in particular, we try to make pretty explicit references to how property systems work and how economic thinking works. So through that lens, or those lenses, we've tried hard to bring in a bunch of different people over the years, and some are unfortunately no longer with us. Herb Schwartz was someone many of us enjoyed working with, and he's passed away. The book started a long time ago. It's the last time I lived in Washington when I was a law clerk for Judge Rich, and we tried very hard at the time to make the book reflect the community at the court. And so we included a lot of voices explicitly, and in fact used the proceeds from the book to create a charity, the Federal Circuit Historical Society, as a way to encourage other young academics and practitioners to write their ideas down and to reflect the ideas of the community. We've really tried hard in the book to emphasize the treatise and academic book models at the same time, with the hope that the book is easy to teach, but also easy to learn from or easy to reference. And I think that the evolution of the book over the years has really reflected that plurality of voices. So the book has gotten longer. It's also then gotten shorter. And, you know, as we all know, as academics who write lots of pages and lots of footnotes, sometimes it's easier to make them longer than it is to make them shorter. And I think that the shift in the author team has really been just essential in helping to refine the book and do that hard work of making it shorter, which we hope makes it both more accessible and more clear. So yes, we cover patent law. We try hard to locate it in a policy and practice space, and then throughout the book make references to both the policy and the practice. So I'll pause there and just say it's the community and the plurality both in the book today and that have supported the book over the years that for me at least has been the most fun and enjoyable, and I hope for the users the most efficient and effective.
Thank you, Scott. Our final panelist is Lisa Larimore-Willett, Professor of Law, and Justin M. Roach, Faculty Junior Scholar at Stanford Law School, and co-author of Jonathan S. Mazur and Lisa Larimore-Willett, Patent Law Cases, Problems, and Materials. Welcome, Lisa.
Great. Thank you so much for having me. Hopefully you can hear me and see these slides now. So you can download and read our casebook for free right now at patentcasebook.org. Order this low-cost version through Amazon if you want the print version. And for adopters, we also provide a Word version, a detailed teacher's manual, and PowerPoint slides. And to answer Nicholson's question from the Q&A, we plan to update this every year, and we're already gathering feedback from the instructors who've adopted it this fall. So the website describes our main goals beyond lowering costs for students, which are bringing conceptual clarity to complicated doctrines with a focus on good pedagogy, placing patent law in its social context, and I think most importantly, really centering the book around practice problems and other techniques to encourage active learning in the classroom, and including out-of-class assignments, as well as in-class multiple choice polls or small group activities. So I'll just quickly give some examples of how we do this in the 102 context to illustrate. So we organize our 102 chapter around these three questions. And we found that the one that students often have the most trouble with is the first one. Like, even if something falls into a statutory category like printed publication and has all the elements, is the timing such that it serves as prior art under the relevant 102? So we have graphics like this for both the old and new 102 to help illustrate the statutes and the ways that something can destroy novelty. And then we have a bunch of short practice problems that ask students to apply these provisions. So our adopter materials include quizzes with these that can be imported into Canvas for students to complete on their own time, as well as PowerPoint slides that can be used to do them during class, and answers to all of the questions. For doctrines that are more multi-factor balancing tests, like whether something is a printed publication, there are some cases in which we think there are better ways to help students apply these tests than just reading through a lengthy case or two. So for the example of printed publications, we start with our overview of the doctrine, and then a number of short examples of cases that came out each way. And then we have various practice problems like this that ask students to apply these factors that instructors can go through during class. And if you're using something like clickers or polling devices, students can do it on their phones. They can be useful for starting discussion on these questions. So for example, here's a slide from our PowerPoint deck that's based on the first practice problem on printed publications that asks students to commit to a position before anyone starts talking about it as a way to engage everyone in the classroom. And then to understand anticipation, we begin with a very simple example to introduce the idea of claim charts based on the Swiffer mop. Then we have students fill out a claim chart with another straightforward example where all of the elements are explicitly there to have more practice with this idea. And then we have some cases and practice problems on the trickier issues like inherent anticipation. And in general, when we're using cases, we've heavily edited them to make more space for our own exposition and for practice problems. And we also use MPEP excerpts where we think they're helpful for helping students really understand and apply the doctrine. We also have a lot of discussion questions that raise both doctrinal and policy issues from a variety of perspectives. So here's quickly 2 examples that attempt to surface some issues of race and gender and other aspects of identity that relate to non-obviousness doctrine. And our teacher's manual offers suggestions for encouraging inclusive classroom conversations on topics like this. And our sense is that students really appreciate it when their casebooks highlight diverse perspectives and voices. This came up repeatedly in my course evaluations from the first time I used this casebook in the spring. It's been mentioned by our adopters this fall. It's one of the things they've really enjoyed about our book in addition to the problems. So I'll just conclude by letting you read this excerpt from one evaluation. And as you're looking at this, one final note is that we have 30 pages at the end of the casebook on international and comparative law that I think can be used as a standalone reading with some nice exercises. And it's drawn from a seminar I've taught on that topic. So if you're interested in expanding your international coverage, you might be interested in that. So I will stop there.
All right. Well, thank you to all of our authors for giving us the descriptions of their patent law textbooks. We're now going to turn to some big topics in law textbooks and also dig into maybe some patent law topics as well. So meanwhile, if anyone in the audience wants to ask a question, please type it into the Zoom Q&A. I'll read as many as I can. And I know some of our author panelists are already responding in the Zoom Q&A, which is fantastic. So I'd like to start with a big picture question. So some of you have written books that are published with traditional legal publishers such as Wolters Kluwer, West, and Carolina Academic Press. Others have self-published their textbooks. So what are your thoughts on the benefits and disadvantages of each of these approaches? And I'm asking my panelists if you could raise your hand, and I will do my best to call in the order of hands being raised. All right, Lisa, let's hear from you then.
I mean, so I think the case for doing it yourself from self-publishing is the cost advantage is huge. It's free for students who are reading it on their PDF, and students particularly appreciate this given costs associated with legal education in general. I have not worked with a traditional publisher, but from talking to other people who have, my sense is that they don't add a lot of things that I need. Like, it was not hard to create a Word document and put it on PDF and put it up on a website and publish it with Amazon. Like, self-publishing through Amazon is relatively simple. And we're a small enough community that it's relatively easy to advertise to the Relevance audience here. So even without a publisher, there are a bunch of professors who are now using our casebook this fall. So I guess that's the case for doing it yourself.
John?
So I think that's an excellent summary. I'm not so sure that the cost feature is as important as Lisa suggests. I think that many schools, the cost of law school education is high, and the cost of books, I think, is a fraction of the total cost. I think many schools that give away scholarship aid also nowadays consider scholarships to help defray the cost of books. And some students, when you ask them, if you use free materials, at least in the past, have said, gee, I'd rather have just a book. Just get me a book. I can buy a used book. I can buy these other things. And so I'm not so sure that's as important, especially if many of the people who take patent law specifically are going to practice patent law. I mean, most of the people in my class are not just taking it as, oh, I wasn't sure between labor law and, patent law, and, this fit my schedule better. So if they're going to practice it for a while, they might want a permanent book. Much like out of all the law school books I had, I've thrown them all away, I think, except for the Hart and Weschler book, which I do keep on my shelf just because it's such a classic. The drawbacks with publishers are significant. I think that's the best argument to move away from this model, because it does put lag into the system, which is frankly unjustifiable, and they have to do a better job. We had lag this summer. We gave them months in advance, and they still could not really meet an August deadline for getting the books available. And that's just I don't know why that happens. That's just unacceptable. They did get it out electronically very quickly. So we sent it to them, and by the end of the week, it was electronically available. So there was that benefit. But they have to do better on the physical books. The main drawback, I think, is that to the extent that you want the book to have some degree of prominence and influence, it may be hard to get that with the teaching materials. And Lisa and Jonathan's book is, as they said, that it's really dedicated towards teaching. It's teaching materials. And if that's your number one goal, and you're not trying to summarize the literature or put up something that might be cited by courts or brief writers as something that tries to sort of be something more like a casebook treatise, then I think the publishing model, the self-publishing model, is better. But I guess we're still stuck in that. We're the older, one of the older casebooks here, and we do get a lot of cites to the casebook, and I think if we moved it to just something that's downloadable on SSRN, I think we might lose that. Thanks.
Mark?
So I've got a traditional published couple of case books and now this open source book. So I thought I ought to speak to this question and say that I agree with both John and Lisa. They're obviously both correct. I do think the shortcomings of the traditional publishers are well articulated, and I've experienced them firsthand, no doubt about that. I would say that they can do a good job of getting the book out to beyond our small community. And in patent law, there are a number of adjuncts who teach or want to teach, and that's true of trademarks too. And my experience has been they do an okay job of getting out to those folks. So there's that. They can be good, the traditional publishers, at supplementing the kind of feedback that otherwise we would get directly from you all, because they are systematically going out and talking to adopters. And so they can be good about that. But the drawbacks are manifest, and the drawbacks have been the subject of certainly many conversations that I've had with our publisher, sometimes very frustrating conversations, but sometimes pretty productive ones too, about other strategies to deal with price, trying to get them to speed up, and those sorts of things. So I think it's a really interesting ongoing dynamic. I think that there's pros and cons to both, and it's very interesting to continue to discuss it and see how it evolves.
Jonathan, what are your thoughts?
Thanks. I mean, Lisa already spoke, so I didn't want to take up too much airtime, but if there are no other hands in the air, I just wanted to respond sort of quickly to a couple of things that John said. And I used the Burgess and Duffy casebook for every year that I taught patent law until we wrote our own. And I really like that book, and I have a lot of respect and appreciation for what John and Rob did with it. But a couple of things. I mean, the contrast that John was drawing was not between books published with the traditional publisher and books that were self-published. He was drawing a contrast between things that are books and things that are a collection of teaching materials. I think he referred to our book as teaching materials once or twice. But that's not like the comparison that's really at hand here. What we wrote was a book, just as much as anyone else in this group has written a book. Sarah and Andres and Sarah, they wrote a book. It's available as physical book. Like you could put you can put our book on your bookshelf just as much as you can put John and Rob's book on your bookshelf. It will hurt your feet if you drop it on your toes just as much as their book, maybe a little bit less. It's a little bit soft cover as opposed to hardcover. You could probably get a hardcover version. So all the virtues of like having a reference text that you can refer to and all of that, those are capturable with a self-published book as well. Similarly, I mean, the point about sort of wanting to be in conversation, wanting to write something that looks more like a treatise and functions more like a treatise, that was most certainly one of our objectives as well. And when you read through our book, you'll see that we try to engage in a series of areas of patent law where we think that the law is unclear, that the courts are confused, that the scholarship is divided, et cetera, et cetera. Now, I mean, whether we're successful or not is something for the readers to judge. But again, like, that's something that you can, that has like, whether you do that or not has nothing to do with whether you self-publish or go with a traditional publisher. The distinction between going with a traditional publisher and self-publishing is just much more about the cost of the book and whether the publisher is going to do any work in disseminating it or any other, engaging any other activity that will be helpful to you.
John, I'm going to give you the last word on this topic.
So everything that Jonathan said is a fair, comeback or counter argument to what I said. I will say this, that we get the Mergis and Duffy casebook gets cited a fair bit by scholars and occasionally by courts, but we're actually sometimes shocked by courts that are clearly reading our stuff and don't cite us. And I think they don't cite us just because they because it's a casebook and they think like that's a teaching material. And I do think that putting it one step further, that it's self-published and on SSRN, I hope that the judges are going to be willing to cite such things by prominent, good scholars. But I guess I worry about it. I mean, it's already that they seem to discriminate against casebooks. They'll say things that are almost verbatim what we say. They'll cite the same cases but don't cite the book. And I just worry about that. I just worry about them thinking that it might be that it's uncitable because it's really teaching materials. And I agree with Jonathan that self-published casebooks should be viewed in the same way, but I'm just not sure that that's the reality we're living with. Thanks.
As a blogger, I feel your pain. So I want to move on to another topic, which is your textbooks specifically. So how do you visualize your textbooks being used by professors and students? How would you like them, if you could suggest, hey, this is how I want you to engage with my textbook? How would you like them to engage with your textbook? Craig.
Yeah, the point about durable relevance, Jason, comes up. I mean, some of the best emails I get from students are emails that say, I'm a 2-year associate. I remember having your patent class and I had a problem. I'm writing a brief and I consulted your book. I remember this point from class, and they had the book in front of them with some slides that I provided as well that I give them. Obviously you want them to use it in the classroom and read the assigned materials, but the fact that they continue to see relevance in it after they've been graduated is terrific. And the more that happens, the better as far as I'm concerned, because of the expense and so forth. But also, you want the book to, because you write it in a way that it's designed for that, and the fact that it is used that way is very gratifying. And I would say in terms of professors, I mean, the best thing I get from professors who adopt it is the feedback. I just get terrific suggestions from adopters who've made the book better over the years, undoubtedly. And that has been very, very helpful. So I'll end that there.
Thanks. Sarah.
Hey, so in addition to just the normal using it in class, we do hope that our book would be a resource for students who are starting to research in patent law, writing notes, doing that kind of thing. And I'll say one thing that's kind of surprised me since we kind of put our book out there is the amount of interest we've gotten from outside the academy, from practitioners, especially those internationally. It seems like there's been a lot of interest in having a free resource for patent law, not just in the classroom. So that's pretty cool. And we certainly welcome and encourage that kind of use.
Dan.
So I think the one thing that we would like adopters to do is embrace some of the signposting and the foreshadowing that we included in the text, to sort of situate students along the way and somewhat often. we do our best at the beginning of each chapter to remind students where we're coming from, tell them a little bit about where we're going. And we intersperse some chapters to just sort of regroup. Like we have an overview of patent litigation chapter where we kind of have an opportunity there to have a short refresher on all the validity law that they've learned so far. A little bit of a reminder of some of the introductory texts where we're talking about, infringement and injunctions and why you want patents. So that kind of, I think, signposting and road mapping is really something that we want our adopters to do. Our teacher's manual, I think, does a lot of that as well. We're very specific, in calling out things that we think students might have forgotten, students might struggle with. And along those same lines, in the text and in the manual, we would like professors to acknowledge when something's hard, or when something's going to be confusing, at the outset, and just let students know that there are a lot of challenges in patent law, like any other area of the law, and to just be upfront about that. Especially, we talk about this in our statutory subject matter section, where there are not some clear rules, and I don't think we want our adopters to attempt to pretend that there's just some black letter rules and that's all you need to know.
I like that idea of pacing, kind of pacing through it and kind of having times for some respite, and that's great. John, what are your thoughts?
So I think I agree with a lot that's been said, but I won't repeat that. I will say one thing that our casebook really tries to do, and especially since I've tried to push the casebook in this way, but Rob already did believe this, is we wanted students to get the full sweep of history, not just what things are being discussed in the federal circuit today. We wanted them to understand where patent law has been, and that it is changing. So for example, to give a concrete thing that was said earlier, Dan Breen said that, they dropped, they have a footnote on the reverse doctrine of equivalence. And we really think that's not, I disagree with that. And, it's just like, panel isn't good if you don't have some sparks fly. The doctrine of equivalence, the reverse doctrine of equivalence, is Supreme Court law that is never been overruled. And the Federal Circuit has proudly sometimes said that they have not followed it. They've said they've never used it in the history of their court. And I think, we're pushing back on that a little bit. We're saying, look, the Federal Circuit gets reversed by the Supreme Court, sometimes unanimously. Sometimes in cases that I've helped litigate, it's not, so clear. Like, don't, look at the whole history before you decide these things. The other thing is that we do also try to engage patent law as part of law in general. So we include statutory interpretation issues. We include administrative law in the chapter on legal process. We try to orient the patent law in the general legal universe.
I muted myself. So often I think in patent law, like, I could solve this problem with the reverse doctrine of equivalence. It's like that golden thing. So I love the fact that you discussed it in great length. I learned a lot from reading your book, even though I do not really teach it very much in my patent law class, to be honest, these days. All right, Scott, let's hear from you.
Well, I guess I would just say I think we share so many of the great ideas that others have mentioned, but I'll just say in our book, we try very hard to make sure that the students see others asking the questions that the students might themselves want to ask, so that they don't feel shy asking. And we also try very hard to give very clear and frank answers, including frankly saying when there are a plurality of viewpoints on the answer. And we have, throughout various editions of the book, and still do maintain, a range of online supplements and teaching materials and slide decks that we hope, let's call it, teachers can use, but also, frankly, most of them are designed to be practical user guides for those who may at one point have considered themselves a student, maybe because they took a class or one day came across a case as a law clerk or a judge or a lawyer, but once again find themselves needing to quickly bone up on some particular doctrine. And we try very hard to make both the book and the supplementary materials designed to give them very easy, ready access to a broad range of ideas that we hope transcend both time and place, so that they are grounded in history with references to what has come before, as well as we try to speak explicitly in the language of others, other legal systems, not just the US system. And that way, if someone's thought about, for example, the concept of description or obviousness, or you pick your doctrine, but they've heard it discussed in another national system. So for example, maybe calling it inventive step rather than obviousness. We try hard to show how some of those linguistic frameworks transcend geographics or national systems, and then also how they transcend our own time frames. We, of course, had a requirement for invention before we had 103 and obviousness. And we try to be pretty explicit about what folks liked and didn't like about those different linguistic frameworks.
All right, Craig, bring us home on this topic.
Sure, very briefly, just to echo John's point about telling patent law's narrative and sort of broad sweep of history, I think is absolutely key. Patent casebooks can't be advanced sheets, right? And so that balance between anchoring patent law in history as part of the story, and yet being topical, but avoiding the trends, I think is one of the challenges that I've had over the years, is that how do you sort of maintain that balance? And I would err on the side of the historical narrative all the time, because that story needs to be told. Students need to get that more so, and they're more likely to get that in the classroom than they are in practice. That's all I wanted to say.
Thanks. So I have a few minutes left. What I'd like to hear from you all about is not so much about your own textbooks. We talked a fair bit about those, but other textbooks. What do you like most about other authors' textbooks, especially other patent law author textbooks? Sarah?
I really like the problems in Lisa and Jonathan's book. And I think it's cool that I think you could actually incorporate them in another book. I mean, actually, we're almost at the point right now where you could almost do an amalgam, right? Like pick a chapter here, patent book smorgasbord. But I love the problems. So thank you for sharing those with the community.
John?
So I love the fact that there are so many of them, because it allows me to very concretely tell my students why an intellectual property right is not a monopoly. Rob and I have a copyright on this. You all have copyrights on it, but we're in intense competition with each other. And I think that's a great lesson. And I like the diversity. And a second thing is the organizations, though there's similarity, I spent a lot of time rethinking our organization. And I think a lot of casebooks were organized the way we previously were organized, which is to have 101 first, and then novelty, and then disclosure, roughly. I think the Burstein book is that way, the Edelman Rader, Janus, and Keefe. Craig Nard, I think, came up with an innovative way, which is to do disclosure first, and I thought a lot about that. Interestingly enough, Jonathan Mazur and Lisa Wallet's casebook wound up exactly the way we reorganized it, and I think we did it independently, which actually gives me some sense that it might be right. Which is that we put 101 last now. It basically went from first to last. And that's crucial, I think, because the major issue associated the major issue associated with this is do the other doctrines do the work? And it's hard to understand that until you've covered those other doctrines. So I like that there's so many case books you can see experimentation going on and think about whether it's right or not.
Thanks, John. Jonathan, what are your thoughts?
Oh, I just wanted to say quickly, I love the discussion of forms of patents other than utility patents in Sarah and Andres' book. I mean, I think that that's one thing that book is doing that really distinguishes it from just about every other book out there. And that discussion is so comprehensive and sort of rich and nuanced in a way that, the treatment of those topics in a lot of other books, while good, can't quite match. And so it's, it's only very appropriate. Like when I think of design patents, I really associate Sarah with that field. And so I think that that's a real triumph for that book.
Craig, what are your thoughts?
I think that the problems in, just to echo Sarah's point, the problems in Lisa and Jonathan's book were just terrific. Lisa, I wanted you to keep going with your slides. I thought those problems were just wonderful. And, it sort of motivates me to sort of think through that as well. It's a lot of work to do that. The other thing I would say is simply a nod to Rob Mergis for setting the standard in the early 90s, right? When he came out with his book with Mickey Press, when he was doing his JSD work at Columbia, and all his great work he did with Dick Nelson, that sort of, for me, set the standard, right? And then John came on and just made it better, which we would expect, right? And so for me, that book is the gold standard, and then there's sort of everyone else, if I can say. But we learned a lot from Rob, and then John coming on board. So I think that I just wanted to say that's just been terrific for mainstreaming patent law a bit into classrooms in law schools, because copyright law with its beautiful First Amendment had the spotlight for all these years, and then patent law was a late comer, right? And I think what Rob did and then John later on is kind of brought us all into the mainstream of that. So that needs to be recognized. So I want to thank them for that.
Thanks, Craig. Dan?
I have a similar comment as what Jonathan said. I really like Sarah and Andres' book and the inclusion of design patents, and plant patents obviously didn't make the cut in my book, but I fully agree that having a design patents chapter, and we have one in our book as well, is important. I mean, for us, the reason was it comes up more and more often, the relevance of design and design patents, patents in the US and then registrations everywhere else. It's becoming important to a lot of people. A lot of patent practitioners might not expect to see it in their careers, but it's going to come up, and it comes up increasingly often. So I think that's a really great addition to your book. And also, I think the sort of law forward, law at the forefront as your philosophy really does set the scene right to be open to students from all backgrounds. I mean, at some level, law is law. You've got technology involved here, you've got a different history, you've got different goals, but I think it really helps for students to just have the scene set for them in that way.
Thank you so much for all of your thoughts. We are unfortunately out of time for this panel, which is too bad because I have like 15 more questions for y'all. Like, why did you choose the publisher you chose? What do you think about case notes? Should professors assign them? Should students read them? And so much more. So maybe we can have a future discussion. But for now, we're going to wrap up. Thank you all so much for joining us. And we're going to take about a 15-minute break now, and then we'll have our next panel discussion at 3 o'clock. So I will see you all then. Thanks again for joining us.